Page 41. Statement of Defense. Honorary Court, Judge Snow. There is no case to answer, there is no offense committed by the defendant/s. The duty of a parent with regard to education law has been and still is upheld, provisions have been made and seminars offered at corporate rates, free to the local users. On the contrary, it is the claimant's conduct that is unlawful and committed deliberately for the entire purpose of personal gain and revenue, monopolizing service provision with their mediocre and ineffective one. 1. Under Business Law, Department for Business, Innovation and Skills, gov.uk, and the letter from MP Fallon, El Sotelo Training Limited Umbrella, lean social enterprise/franchisors have the right of independence and to challenge a lack of provisions for specialist gifted education in the Triborough, specializing in young carers and entrepreneurs, but not exclusively. As maintained ever since our reply email dated September 27, 2013 reply to letter dated September 18, 2013 by Kathy Sioref, Children Missing Education, CME, Field Worker, the letter is illegal as it misstates the powers of the Lee. Graham publishes 2 new letters on home education. www.grahamstewart.com web link. www.grahamstewart.com web link. Redacted letter to Elizabeth Spearman re Triborough elective home education, May 8, 2014, illegal SOW issued on June 6, 2014 to Gabriel Taylor. Page 2 reads: the guidance issued by the Triborough therefore fundamentally misstates the powers and responsibilities of local authorities in this regard. I would be grateful to learn what action you will take to amend the guidance so that it properly reflects both the law and the Department for Education's guidelines. Rather than imposing a monitoring regime on home educating families, it would be better for the Triborough to concentrate on improving the support and resources available for home educating families, in accordance with their individual wishes. 2. The evidence can be presented in any format by our alternative education new education paradigm, referred to by Lee as otherwise than school or EHE. In our specific case, this project-based learning, PBL, is delivered in the legal framework of an independent private company limited by guarantee, CLG, lean social enterprise. El Sotelo Training Limited CEO is Lucas Sotelo. Gabriel Sotelo PR Limited Co is Gabriel Sotelo, aka LG Sotelo. There were never any specific concerns, verbal nor written. At no point was there evidence or grounds for this unlawful act, illegal SOW, as there cannot be, as we have not done anything wrong. On the contrary, we are community leaders in world-class education, provided as a cottage industry without any external funding, and have challenged benevolently the local authority, being out of touch with what the local BME families need in terms of education that would improve social mobility and justice. This is collusion and a silencing act, an abuse of process, including their own complaints process, and the only reason we could see is monopolizing the service and for the revenue's sake and personal gain. In our view, it is a case for judicial review. Bringing this to the attention of the court, our duty as citizens we believe is done. Furthermore, as far as the Data Protection Act goes, this is a flagrant abuse of our data for the use of statistics, funding and referrals. We had never given consent, there were no concerns, and in order to be considered as elective home education, EHE, there are no grounds and again, no written consent. The grounds for elective home education by law are: either the child attended a maintained school, or there is evidence that there is no education provision. None of this applied to us with exception for Lucas Sotelo from 2000 to 2007, on the grounds that he went for 6 months of 2000 to Marlborough Primary School, and since 2007 has set up his own education provisions. Ever since the mentioned letter of September 18, 2013, we have maintained that this is an abuse of power, trust, and process. That the employees from Triborough Strong Claimant have deliberately went beyond their legal, professional, and moral scope on the pretext of the interest of the child and with much more sinister hidden agenda in reality. These are false allegations that amount to slander, defamation, and are damaging both psychologically and financially to the young carer entrepreneur Lucas Sotelo, who is providing a blueprint and success in education to his younger brother, specifically delivered as a coaching textbook. This amounts to social engineering of Victorian attitudes versus accelerated learners and community champions. New education enterprising paradigm. 3. For the purpose of a common point of reference. Suitable efficient education. Government Home Education Guidelines for Local Authorities www.gov.uk web link. Quoted also in www.edyourself.org web link. Edyourself, School Attendance Orders, reads. 2.3 The responsibility for a child's education rests with his or her parents. An efficient and suitable education is not defined in the Education Act 1996, but efficient has been broadly described in case law as an education that achieves that which it sets out to achieve, and a suitable education is one that primarily equips a child for life within the community of which he is a member, rather than the way of life in the country as a whole, as long as it does not foreclose the child's options in later years to adopt some other form of life if he wishes to do so. To elaborate, Sotelo education is efficient, a goal is publishing books, and writing documentaries to promote social justice based on our own experiences. Sotelo education provision is suitable as it provides coaching tools, transferable skills in the coaching community, both online and local. Sotelo education is specialist, remedial and world-class training with cutting-edge technology provision by 3 founding members. Further, in the case law, clearer interpretation, to quote www.homeeducation.org.uk web link. Elective home education, legal guidelines. Diverse approaches to home education. The principle of parental choice is paramount. Families are entitled to choose what they feel to be the most suitable educational approach. One system cannot be expected to cater for the needs and interests of all individuals. Many fail to thrive or reach their full potential whilst receiving formal instruction in a school environment. A variety of alternatives in education is therefore important, and the law allows for this diversity. A clearer interpretation of some terminology used in the 1944 Education Act, replaced by the 1996 Act, was gained in the case of Harrison and Harrison v. Stevenson, appeal to Worcester Crown Court 1981. The term suitable education was defined as one which enabled the children to achieve their full potential, and was such as to prepare the children for life in modern civilized society. The term efficient was defined as achieving that which it sets out to achieve. Clearly, this definition covers a great variety of educational approaches. There is no one correct educational system. All children learn in different ways and at varying rates, and chronological age has little bearing on the process. Reference from www.homeeducation.org.uk web link. This document is the work of a large number of home educators, including, but not exclusively, members of Education Otherwise and Choice in Education. It was edited by Neil Taylor, and checked for legal accuracy by a team of home educating lawyers. From Choice in Education, an independent publication for home educators, PO Box 20284 London, NW13WY. Available free online in a choice of formats at www.choice18education.co.uk web link. 4. Statement of witness is our overall proof and evidence of distorted view, discrimination, and prejudice of the bureaucrats abusing their position, Institutional abuse referred to in own exhibits. Enterprise/family/personal statement of damage. The pursuit of this family-run business and its members is despicable abuse of law in a democratic country. Ever since the initial letter of inquiry, September 18, 2013, in an email reply to which we clearly stated our position as a seminar provider, v.skool, and that we were beyond the duty and powers of the LE, unless they had genuine concerns of the welfare or non-provisions grounds. The background of abuse of trust and position by labeling a child wrongly sen when he was obviously gifted, and there were no provisions in the council for such, achieving fabulous results on shoestring budget alternative which was stated as long-standing educational dispute, unresolved. The claimant decided to repeat the same abuse for the youngest child. No one in their right mind would allow this psychological casual mental cruelty, and the duty of the parent to prevent such institutional abuse was evident despite the damage, lack of accountability and transparency, and playing the game of institutional immunity based on internal policies that go against legislation and government guidelines for the sole purpose of revenue and personal gain. The interest of children is only a pretext to intimidate, harass, misinform, and thus a gross conflict of interest by corrupt and incompetent officials. This should not be happening. Reference, adoreself.org web link. Defense of education otherwise than at school. S.443 Education Act 1996. 1. If a parent on whom a school attendance order is served fails to comply with the requirements of the order, he is guilty of an offense, unless he proves that he is causing the child to receive suitable education otherwise than at school. 2. If, in proceedings for an offense under this section, the parent is acquitted, the court may direct that the school attendance order shall cease to be in force. 4. A person guilty of an offense under this section is liable on summary conviction to a fine not exceeding level 3 on the standard scale. Polite request to revoking the school attendance order / copyright material, Freeman Report, / data unlawfully held and used by the Triborough for funding / statistics. S.442 Education Act 1996. 2. If at any time the parent applies to the local education authority requesting that the order be revoked on the ground that arrangements have been made for the child to receive suitable education otherwise than at school, the authority shall comply with the request, unless they are of the opinion that no satisfactory arrangements have been made for the education of the child otherwise than at school. 3. If a parent is aggrieved by a refusal of the local education authority to comply with a request under subsection 2, he may refer the question to the Secretary of State. Sotelo Barefoot Coaching Client's Profile.